Thank you, and I'm very honored to have been given this honor by your university. And I especially appreciate the two speeches made that really seriously took on my work and tried to talk about it. I'm flattered to think that this wasn't just a random pulling a name out of the hat, but that you actually thought about what I work on, what I do, and how it relates to the mission of your school. So that makes it especially a good honor. I'm known, I think, particularly for writing about corruption and its relationship to politics and economics and law. But today I'm going to speak more about the administrative law side of things that was mentioned before. I'll be giving a talk this afternoon at the conference that you've organized that will be specifically talking about corruption. But in this talk, I want to talk about one aspect of what we mean when we talk about the rule of law. This is one of those phrases that, as you all know, gets thrown around, used in all kinds of vague, positive ways, but means very, very different kinds of things. So to some people are really just talking about clear, consistent, market-friendly rules, thinking of the law as a kind of background within which the market operates, and the main idea is clarity, stability, knowledge about market-friendly parts of it. There's another part of the rule of law that particularly focuses on individual rights and legal accountability for past wrongs. It's another important meaning of the rule of law. But I wanted to speak about a third meaning, which has to do with the accountability of public institutions themselves to law, and the way in which public institutions are sort of structuring private sector behavior in the public interest. And so it's this kind of link between law, public law, administrative law, and the making of public policy that I want to especially talk about. I want to distinguish myself from two strands in the literature. One which is saying, look, everything's converging. Things that are happening in Peru, in Argentina, in Mexico, in Italy, in the U.S. are all kind of converging on one thing. I think there is some convergence, but that's kind of oversimplifying things and not taking enough account of differences across countries. And the second thing I want to distinguish myself from is another strand of the literature that imagines that colonial heritage and history are inevitably, in some iron way, connected to the present day. Of course, there's some causal connection there. But the idea that somehow history is, in some rigid sense, a destiny, I think, also needs to be rejected on an empirical matter as well as a normative matter. What I want to think about is more the broad question of public accountability and administrative law in states that have democratic structures, that have elections and a representative legislature. I appreciated Professor Sarden summarizing an earlier paper that I wrote that focused on democratic structure and electoral structure, because it sets a good background for what I want to talk about here, which is the organization of the administrative process, and the basic point that no democracy in the modern world is going to leave or put all policymaking inside of the legislature. A lot of policymaking is going to happen inevitably inside the bureaucracy or inside the independent or not so independent regulatory agencies. And that because of that, it's very important for democracies to think about and take more seriously, and I think many have, the democratic legitimacy of those actions. So what do I mean when I'm talking about accountability? That's another one of those words like the rule of law, that gets used for all kinds of things. And I think it's one of these words that's difficult to translate into Spanish, although I know you have the concept. I mean, it sometimes is translated in a way that sounds like, or is referring to fiscal accountability, and being sure the books add up right? Of course, I'm talking about something much broader than that. So I want to distinguish three kinds of accountability. Performance accountability, rights-based accountability, and policy-making accountability. So performance accountability is really given some policy, it's not policy-making, given some policy, is the policy competently carried out in a way that isn't riddled by corruption or inefficiency and waste, and that's, of course, an important piece of it. Second, accountability has to do with whether it's the administration is accountable to principles of individual rights, of human rights, of individual protection of individual against the overarching state. But third, there's what I want to focus on, which I'll call policymaking accountability, that looks at the policymaking process inside the executive or inside other agencies that are making policy, and asks whether this activity is accountable to democratic principles. In other words, policymaking outside of the legislature. So what am I talking about here? What's the sort of framework of the argument? This first delegation of policymaking to the executive or to some other set of bodies outside the legislature is inevitable. It's going to happen. You can't imagine it's not going to happen. Secondly, given that that's true, how do we, there's a need for that activity to be politically accountable. Three, how could that happen? How could we do it? What are the options that are available, given that we're not talking about direct electoral accountability? And four, and here's where the law particularly enters in, what can be the role of the judicial system or the courts in overseeing what happens inside of the agencies without the courts themselves taking on a direct policy making accountability, or not accountability, but policy-making role. They shouldn't be actually setting the tariff rate, as I heard your Supreme Court just did recently. All right, so first, why is it that the answer to this problem of policymaking, public accountability of policymaking, can't be solved by just saying, well, the legislature should be obligated in some constitutional manner to make all of the policy decisions in the law, and then we're done with it. Well, I think if you think about it for a minute, you'll understand that this is a role that the legislature is likely to perform quite poorly if you put a strong requirement on them for many reasons. They're not expert. You want to regulate in telecoms or electricity or something like that. Most of the members of the legislature know very little about that. And so they rightly say, I want to set a framework within which this will happen, not make the details.